Good afternoon. I'd like to call the Finance, Ways and Means Committee to order for April the 2nd, 2024. Mr. Clerk, would you please call the roll?
Representatives Barrett, Boyd, Camper, Cochran, Crawford, Faison, Freeman, Gant, Garrett, Hawk, Hicks of Hawkins, Hicks of Washington, Kiesling, Lamberth, Love, Lynn, McKenzie, Miller, Moon, Parkinson, Shaw, Sparks, Whitson, Williams, Zachary, Vice Chairman Baum, Chair Lady Hazelwood. Madam Chair, you have a quorum.
Thank you, Mr. Clerk. Are there any personal orders or announcements? Chairman Hawk.
Thank you, Madam Chair. A bit of unfortunate and sad news for those of us that had worked with Chairman and former Speaker Pro Tem Judd Matheny. He's passed away today. So he was elected in November of 2002 with Representative Lynn and myself. We came in and really want to express our condolences to the Matheny family for the loss of Judd Matheny. He's currently serving the position of County Mayor of Coffee County. So if, as you say your prayers, keep the Matheny family in your thoughts and prayers. Thank you, Madam Chair.
Thank you, Chairman Hawk. And we definitely, I had the opportunity to serve a couple of terms with Representative Matheny as well. So it's certainly a sad day. Representative Lynn.
Thank you, Madam Chairman. I just wanted to express my condolences too to his wife and children. His children were young 20s, I believe. So it is a sad day for the Matheny family, and I hope we all remember them in our prayers.
Thank you. Representative Shaw.
Thank you, Madam Chair. I'd like for you and the committee to help me recognize a couple people in the audience. For my name's sake, we've got Mr. Shaw from Jackson, who's with the Hospitality Committee, and also I believe I've got Charlie Massey here with me. I want to make sure that I get that name right. He's also here with us. Chris Mathis. I'm sorry. Chris Mathis here with us today. Thank you, Chris Mathis. Thank you.
Representative Shaw, we are happy to welcome Chris Massey with the Titanic Museum, I believe, as well as Brooke Shaw with the Casey Jones Museum. So welcome on behalf of, I know you all are here representing the hospitality industry, and I believe that I saw Hugh Morrow from my district in the audience as well. So welcome. We have 18 bills on our calendar today. So I'm sorry, Representative Parkinson.
Thank you, Madam Chair Lady. I too had a chance to serve with Mayor Matheny, and I always thought he was a good guy. He was always just straightforward and uncut. So I did want to say that. I also want to say on a lighter note that the month of April is Barber Beauty and Health Month. So if you have barbers and beauticians or stylists and health professionals that you know and love, please show that gratitude and appreciation to them this month. And on an even lighter note, today Representative Boso informed us that his grandparents were first cousins. So thank you for that, Madam Chair.
I'm not quite sure how to react to that, Representative, but I would say that Chairman Hawk is very glad that you reminded him about the beauty and barbers, because he's going to make a special note to appreciate his. We do have 18 bills on our calendar. Without further ado, we will get underway. The first item is House Bill 2541 by Speaker Pro Tem Marsh. We have a motion and a second. Speaker Pro Tem, you're recognized.
Thank you, Madam Chair. HB 2541 adds another tool in the local government's toolbox for land use planning. The new tool is a voluntary energy siting agreement. No municipality or county must use this tool. The bill would permit a local government to negotiate with an energy project developer. The terms and the conditions of the agreement must be included in the duration of the agreement, the location of the land involved, a description and design of the project, and any other terms agreed by the local government and the developer. The terms and conditions of any agreement agreed by this local government and local development, the terms and conditions would have to be approved by the local governing body. Once approved from the developer's perspective, the developer would have a vested right under Tennessee's existing vested property rights law enacted in 2014. With that, I'll answer any questions.
Thank you for the explanation. Are there questions for the sponsor? Speaker Pro Tem, you did such a great job. I don't believe anybody has any questions. So without objection, we are voting on House Bill 2541. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. House Bill 2541 moves to calendar and rules. Next on our calendar is House Bill 1607 by Chairman Howell. We have a motion. We have a motion and a second. Chairman Howell, you are recognized.
Thank you, Madam Chairman. This is the annual transportation omnibus bill for the naming of highways and roads, and I have 39 amendments which make up one bill 1607, and I request passage.
Do we have questions of the sponsor? Seeing none? Question has been called. Without objection, we're voting on House Bill 1607. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it, and House Bill 1607 goes to calendar and rules. Next up is Chairman Howell again with House Bill 1608. Do I have a motion? We have a motion and a second. Chairman Howell, you're recognized.
Thank you, Chair Lady. This is the annual transportation omnibus bill for specialty license plates. Again, I have 32 total amendments which make up the entire bill of 1608, and I request passage.
Are there questions of the sponsor? Question has been called. Without objection, we are voting on House Bill 1608. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. House Bill 1608 goes to calendar and rules.
Thank you, Chair Lady and members.
The next item on our calendar, we're going to roll to the hill since that is Chairman Kiesling, and he has to stay with us for the duration anyway. We are going to item number 5 on the calendar, House Bill 2174 by Representative Alexander. We have a motion and a second. Representative Alexander, you're recognized.
Thank you. What this bill does is it allows businesses that are not normal food established businesses, food service establishments to sell water, prepackaged food, coffee during festival for 2 days instead of 1.
All right, you've heard the sponsor, but we do have an amendment, I
We
believe.
do have an amendment.
Drafting code 017269 is what I show.
That is correct.
All right. So we have a motion and a second on the amendment. Without objection, we're voting on Amendment 017269 being attached to House Bill 2174. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it, and the amendment is now on the bill. And I assume that you were explaining your bill as amended.
Yes, sorry.
So you've heard the sponsor's explanation. Are there questions of the sponsor? Seeing none, we'll be voting on House Bill 2174. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. House Bill 2174 goes to calendar and rules.
Thank you, Chair Lady. Thank you, committee.
Item number 6 on our calendar is House Bill 2158 by Representative Davis. Representative Davis, you have a motion and a second, and you are recognized.
Thank you, Chair Lady. I do have an amendment, and it is 017684.
That's the one we have. So does the amendment need to go on first before you explain? Would that be easier?
Yes, ma'am, because it rewrites the bill.
All right. So we have a motion and a second on the amendment 017684. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. The amendment is attached. So Representative Davis, if you would please explain your bill as amended.
Thank you, Chair Lady. Thank you, committee. So what House Bill 2158 does is it allows for the reporting from LEAs to the Board of Education with respect to nurses in our schools. currently right now, there's not any requirement for reporting that information either to the Department of Education or to the Department of Health. So we really don't know what that data is. And so what I'm interested in finding out is how many nurses are contracted, how many nurses are used through a grant or might be attached to a specific student. And so we're looking at gathering all of that information, kind of looking at the number of students that we have that might have chronic illnesses or have health issues, and making sure that we're able to address and meet the needs of those students.
Chairman Hawk.
Thank you, Madam Chair. And Representative Davis, thank you very much. You and I have worked on this since you began, and we started that a decade before then. So just trying to ensure that we have the medical professionals, the nurses in our school buildings themselves, and that the intent of the funding that we're sending back to local school districts is used in this way. We have been talking about reducing the ratio of students to nurses for quite some time, or nurses to students for quite some time. And I appreciate your energy and vigor toward continuing this effort. So we'll strongly support. Thank you, Madam Chair.
Leader Camper, I believe I saw your hand.
Yes, ma'am, you did. Thank you, Representative, for the bill. Similarly, like Chairman Hawk, this is something we've been trying to do for a long time. And I think in your original vision, you wanted to have a requirement for X number, but it seems to me you looked at the situation and kind of decided, let's get the data first, let's get the facts, and then from there we can come up with public policy. Is that your goal?
Yes, ma'am. I think it's important to make sure that we understand fully what LEAs are able to already meet that ratio or that number, what needs that they have, and where we can kind of fill in those gaps. For me, a nurse in the school is a professional that can kind of help triage that student, and that personal relationship that they have with those students, I think, is important, because they're going to be able to tell if Jimmy's coming into the clinic because he's got the flu, or his belly hurts because he's got a TCAP test coming up, or maybe he just doesn't want to go home. And so if you have someone there that has kind of that professionalism there to be able to direct the needs of that student, I think that that's important. And I want to work and collaborate with our LEAs to make sure that we're meeting those needs.
Leader Camper.
Thank you, Madam Chair. Thank you for the bill. It is something that's greatly needed, and hopefully when we get the data back, we can, really take a look at where the need is and then fund it, because I think it's important that we fund these positions and we make sure that we do have nurses in every school at the right ratio. So I appreciate the bill. Thank you, Madam Chair. Thank you, Representative, for the bill.
Thank you.
Are there other questions for the sponsor? Seeing none, we're ready to vote on House Bill. I'm sorry. Representative Love, you got in under the wire.
Thank you, Chair Lady. I think my questions were along the lines of Leader Camper. Just wanted to make sure that, so it's a both and. It's a reporting bill and a encouragement of sorts with the May.
Well, I'll always encourage LEAs to do the right thing and put the monies to ensuring that our students are safe. But this bill is specifically for reporting only.
Representative Love.
Thank you. I was reading section 1 under C, where it said an LEA may use TISA funds to directly employ a public school nurse, and then it gets into the reporting piece. So I guess that's what I was seeing in there.
All right.
Unless that's old language.
So are you looking at 017684?
Yes, 017684.
Okay. And you said section C?
Section 1, then it says Tennessee Code annotated is amended by deleting subsection C and substituting instead the following C, then 1. An LEA may use TISA funds to directly employ a public school nurse or to contract with the Tennessee Public School Nurse Program. Then it says 2, if an LEA does not employ or contract at least one school nurse, then it gets into the reporting piece. So I want to make sure I'm reading it right.
Yes. And so you're correct. They may use whatever funds that are available to them to address that need to ensure that there is a nurse in the school. But that's obviously permissive, and they can, they are determinant as to how they spend their TISA dollars or any other dollars that they receive. I would appreciate and strongly encourage that they would use those funds for that, but it's their discretion. My concern is making sure that we do find out how those funds are being spent and if they are going to address that. And so that's where that reporting is coming in. Does that answer your question?
Representative Love.
Yeah, and I may have asked the question in a different way and not being clear. I was just making sure that it sounded like it was a both and encouragement because it said an LEA may use instead of shall. But I didn't know if that was old language from TISA formula or not.
Representative Davis.
Yes, and so it is an
Okay.
encouragement, and it's permissive. It's obviously, I'm not directing them
Sure.
to use their dollars, even though that was the intent of a lot of those TISA dollars put into that base formula was to address that need.
Okay. Thank you. Thank you, Chair. Thank you, sponsor.
Other questions for the sponsor? All right. Without any, we are voting on House Bill 2158. All in favor as amended. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. House Bill 2158 goes on to calendar and rules.
Thank you, Chair Lady. Thank you, committee.
That brings us to item number 7, House Bill 2055 by Representative Eldridge. We have a motion and a second. Representative Eldridge, you're recognized.
Thank you, Madam Chair, and there is an amendment that rewrites the bill.
It's traveling with it.
Pardon? It's traveling.
That amendment is traveling.
Thank you. Thank you. This bill comes to us from the assessors of property. It sets out to do 3 things. It authorizes the assessor to determine permanent value records. It would allow for tax maps and other documents to be electronically scanned by the Register of Deeds office using the funds allocated to preserve permanent value records that originate in the assessor's office. It will clarify for the assessors how to deal with movable structures that are constitutionally required to be assessed based on their use. And it also authorizes a continuous review cycle for visual inspection. And this will allow for the counties to save money when the State Board of Equalization approves this use. And that's what the bill does. And I ask for your support.
Thank you for your explanation. Are there questions of the sponsor? Question has been called. Without objection, we are voting on House Bill 2055. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. House Bill 2055 goes to calendar and rules.
Thank you, Chair and Committee.
Thank you. Item number 8 is House Bill 2954 by Representative Hardaway.
Thank you, Madam Chair, and good afternoon, members.
You did I hear a motion and a second? All right, we have a motion and a second. You're recognized.
You want me to start over, Madam Chair? This bill, quite simply, will save lives. We're asking our insurance carriers to cover the early detection, when recommended by physicians, for the early detection of prostate cancer. My goal is to create the same type of awareness that we have with breast cancer. And we've been lucky enough to save lives for women over the past few years. And we want to do the same for prostate cancer.
The question has been called. We do have someone who had asked to testify on this bill. So without objection, we will allow, they have traveled to be here to do that. So without objection, we will go out of session to hear testimony from, I believe, Ms. Kavanaugh.
Thank you, Madam Chair.
We are out of session, and Ms. Kavanaugh, you have 3 minutes. And we are asking that your testimony pertain to the fiscal portion of the bill, the fiscal impact.
Good afternoon, Chair Hazelwood and esteemed members of the committee. My name is Sarah Kavanaugh, and I live in Nolensville, Tennessee. I am here today as a volunteer patient advocate leader with FORCE, Facing Our Risk of Cancer Empowered, an organization dedicated to supporting individuals and families navigating the challenges of hereditary cancer. I'm here to express my unwavering support of House Bill 2954, specifically urging the passage of this bill without Amendment 1-0. My testimony revolves around the profound impact of cancer screenings and the critical role they play in the lives at high risk, including myself and the men in my family. The proposed amendment to House Bill 2954 significantly concerns us, as it reduces the bill's intent, making access to critical screenings like the PSA test cumbersome and less patient-oriented. As someone deeply involved in the hereditary cancer community, my life has been directly impacted by the constant vigilance and proactive screenings that come with carrying 2 genetic mutations, Lynch syndrome and CHEK2. While my personal journey does not have a direct involvement with PSA testing, the parallels to the importance of screenings is undeniable. While seemingly manageable, the cost of PSA testing and other testings can be a major barrier to those who have financial strain. Moreover, the peace of mind that and early detection of screenings can provide is beyond anything that a statistic can convey. The proposed amendment 1-0, which shifts the medical decision-making power to insurance providers, it threatens to minimize the patient-centered approach. It introduces a barrier where decisions that should be made in the exam room could be distracted or dictated by policy and cost-saving measures, not patient welfare and medical necessity. And this hits home for me as I consider the well-being of my husband and my brother, who are both of the recommended screening age. The thought of them facing additional hurdles for essential screenings due to insurance gatekeeping is deeply troubling. For high-risk individuals, timely and accessible screenings are not a luxury, it's a lifeline. And speaking off script for me personally, I can't understate the value that my primary care provider had in my healthcare concerns and worries when she listened to me. Her dedication to understanding what my concerns were with my health brought me peace of mind, but it also led to crucial genetic testing and a manageable diagnosis. I am considered a previvor, which is somebody who has genetic risk, but does not have a cancer diagnosis yet. So all this to say that Amendment 1-0 undermines that patient empowerment and doctor-patient relationships by allowing insurance plans to dictate the necessity of medical screenings. We risk the nuanced and personal aspects of medical care that only a treating physician can provide. In closing, I urge this committee to support House Bill 2954 in its original unamended form. Let's ensure these policies reflect the importance of keeping medical decisions in the hands of those who best provide them, our healthcare providers, in partnership with the patient. Thank you for your time and consideration and allowing me the opportunity to provide my perspective on this vital issue. Thank you.
Thank you, Ms. Kavanaugh, for taking your time to be with us here today. Are there any questions for Ms. Kavanaugh while we're out of session? All right, Ms. Kavanaugh, thank you so much for being with us. Without objection, we're back in session, and we have questions for the sponsor. Question has been called. Without objection, we're voting on the question. All in favor, please signify by saying aye. Any opposed? The ayes have it, and House Bill 2954 goes on to calendar and rules. Thank you, Representative Hardaway.
Thank you, Madam Chair. Thank you, committee members.
Next on our calendar is House Bill 2404 by Representative Slater. Representative Slater, you have a motion and a second. You are recognized.
Thank you, Madam Chair, and thank you, committee members. House Bill 2404 is in relation to juvenile courts. This bill is amended, modifies one point in the definition of dependency and neglect. The change in definition would underscore that dependency and neglect begins at the point a case is filed, not at the time a case is decided. And with that, I stand ready for questions.
You've heard the sponsor's explanation. Are there questions? Seeing none. We are voting on House Bill 2404. All in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 2404 goes to calendar and rules. Thank you, Representative Slater.
Thank you, committee.
Item number 10 on our addendum calendar is House Bill 1640 by Leader Lambert. I'm sorry, it's on our regular calendar, not addendum calendar. Leader Lambert.
Thank you, Madam Chairman. And there is an amendment that I filed 017844.
Motion on the amendment.
All right, we have, Leader Lambert, we're showing two amendments. The first one I have is 015789.
That is correct, Madam Chairman.
Okay, so let's get we have a motion and a second, and this is just deleting immediate and changing it to imminent, I believe.
Madam Chairman, there's probably three amendments that are on this one. But I think the other one is traveling with it.
I think we have to add this one. We have to add,
There should be two amendments we're adding today, and I think one amendment that was traveling out of the substantive committees.
okay. All right, so for this moment, right now, let's just do one thing at a time, Leader Lambert. So we are voting on 015789. All in favor, please signify by saying aye.
Aye.
Any opposed? The ayes have it. That amendment is attached. We have an amendment 017844, which is late filed, but it is just a technical amendment without objection. We will take up that amendment. Seeing no objection, we have a motion, we have a second. And this amendment is 017844. All in favor, please signify by saying aye.
Aye.
Any opposed? The ayes have it, and the amendment is now on the bill. And we are, everything else is traveling with it. So now, Leader Lambert, if you would like to explain the bill as we have amended it.
Thank you, Madam
multiple
Chairman.
times.
Many of y'all that were on sub or the other committees have heard me describe this bill, and I want to thank Chairman Williams for all of his hard work on this. Jenna Ludwig was killed by a man who should have been in jail or in a facility to care for him. She was a Belmont student. She was a young soul who was just on a walk on a pretty day. And unfortunately, there was a man that had a gun that never should have had a gun, never should have been out, and he was firing that weapon off at other people and struck and killed this young lady. There are hundreds of people throughout this state that are not competent to assist in their defense. Everybody knows it in the courtroom. Their lawyer knows it. The judge knows it. The DA knows it, but there's just not the tools that they need to do anything about it. This bill, with the funding associated with it, will ensure that if someone is not competent to assist in their defense, then they are not leaving the courtroom that day. They are either going to remain in jail or go to inpatient treatment. And if once safe in inpatient treatment, they can do mandatory outpatient treatment. If they are either involuntarily committed or they will be involuntarily committed for their own safety. The other thing this bill does is with that involuntary commitment, after full due process has been exercised with lawyers and doctors and a judge making the decision, then that person will not be able to possess or purchase a firearm, period, end of story. If this bill had been in place a year ago, I am confident that this young lady would still be alive and her family would not be mourning her loss. With that, I stand ready for questions, Madam Chairman.
Leader Camper.
Thank you, Madam Chair. Thank you, Leader, for the bill. Question on Section 10, I think it is, where the person who commits the felony or Class A, and they're found to be incompetent to stand trial, then they will be put in medical treatment, mental health treatment, some type of treatment. Is there anything in the bill that talks about how long a period of time the individual have to be committed, and how can they satisfy this and eventually be brought back into society?
Leader Lambert.
So for purposes of this bill, I mean, it's a rebuttable presumption that they are a danger to themselves or others. And so a judge is going to have to make a determination as to whether or not there's evidence that would overcome that. But this bill envisions, just as what occurs now for an involuntary commitment, that person is committed for the rest of their life. I mean, either inpatient or outpatient, depending upon where they are in their journey towards treatment and assistance. So there are some of these folks that are able to operate just fine in a group home or even in their own home with mandatory outpatient treatment. But for some of them, they may be in an inpatient treatment setting forever. and that is to protect them and the rest of society. So it's a rebuttable presumption. It's not automatic by any means. But at the same time, this bill definitely envisions that there may be some folks that once they are arrested on a crime, if they are not competent to assist and they are dangerous, then they simply will not be released.
Leader Camper.
Thank you. And it doesn't talk about or address the heinousness of a crime. It's just if it's a felony of any kind or a misdemeanor, class A misdemeanor of any kind, they could conceivably be committed for the rest of their life if it's deemed that they are incompetent to stand for trial of that particular defense, that particular offense, due to an intellectual disability. Is that what I think I heard?
Leader Lambert.
That is correct. I mean, these folks have been charged with a crime. They're never going to be competent, ever. These cases, and almost 20 years of practice in law, I've seen, again, hundreds of these cases come through the system. Every single one of these people deserve and needs help. They do not deserve to be out there just on the streets. Many times when you see someone who is homeless, when you see someone who is in and out of the criminal justice system over and over again, many of those folks fall into this category. They fall into a category where we're not talking about someone who has just a few mental health issues that they're dealing with or has some mild intellectual disabilities. We're talking about folks that have devolved so far that they are not competent to even discuss their case with their lawyer. And so these are some of the most pitiful folks you would ever meet, but unfortunately, they are also dangerous. And so the court will check in on them on a regular basis. I recently got a call on a lady that I had committed after about a 9-month process, because there are some tools out there, but they're very difficult right now. But she had passed away. And for the better part of 15 years, the court and the mental health apparatus in Sumner County had cared for her. She was never competent till the day that she passed. And so if you're charged with an A misdemeanor or above, then that is the process that we're setting up in this. It is a rebuttable presumption. So obviously the judge could override that if the facts would justify it. But the vision of this is exactly what would be necessary in any one of these cases, is that they are inpatient commitment and then mandatory outpatient forever, or until which time they would regain competence. If they ever regain competence, then their case starts over.
Leader Camper.
Thank you, Madam Chair. And lastly, it says here in that same section 13, the presumption established may only be rebutted by clear and convincing evidence that that person does not pose an immediate substantial likelihood of serious harm. So they can come back, and if there is clear and convincing evidence that this person can be brought back into society, then they can come back and petition the court, and then the courts can decide by clear and convincing evidence that they don't pose a threat and they have a way of coming back home to their family. Is that correct?
Leader Lambert.
That is correct. And that's exactly why we put that in there, is to be able to give that off ramp if a judge feels like there's, by clear and convincing evidence, that has been proven. So that is in there. But look, this is a very stringent bill that is extremely needed in this state. And we're as serious as we can get on this, because this is there's just too many people that have been falling through the cracks.
Chairman Williams.
Thank you, Chair Lady Hayeswood. Just wanted to take an opportunity on behalf of Jillian Ludwig's family to say thank you to William Lambert. I know he was working on this bill a long time. He likes to give me credit for it, but in fact, it's his work. And he, after the family contacted me through a mutual friend, I reached out to Leader Lambert, and he graciously allowed us to put an amendment on here to name this bill after this Belmont student, Jillian Ludwig. Her family, Jessica and Matt, are watching today, and just wanted to share with them our heartfelt thoughts or prayers are with them and their family as they struggle with the daily thought of taking their daughter to school, and then with a future and a hope ahead of her, and then having to go back and empty her dorm room at Belmont. Jillian should be with us today. She was a fantastic musician, picked up exercise when she got to Belmont, which her parents were really excited for her to do. But the opportunity for us to take the opportunity to remember her life and legacy in this bill is extremely important to the family as they seek to try to find ways to continue her work as she did contribute to those in need who needed instruments and lessons as it related to their desire to be in the music business or to use their giftedness in the arts. And so wanted to just take the time to thank Leader Lamberth and this body, particularly Chair Lady Hayes-Wood and Chairman Hicks, because had the governor not put this in the AA, this body, I'm confident, would have put the money in to do this. We come up here on a daily basis and we say that some of the work that we do saves lives. I will say that without a doubt, in my mind, that this bill will save future lives of Tennesseans because of the work that we did here today. And Leader Lamberth and his team and the governor's staff and their willingness to meet with the Ludwig family is greatly appreciated. I want to thank this body, and I look forward to seeing this passage on the House floor. Thank you, Chair Lady.
Thank you, Mr. Chairman. I think I speak for all of us who thank you and for your passion, and Leader Lamberth and everyone else who's been involved in this, and to the Ludwig family. It's small comfort, but for this thing that we can do, naming this bill for your daughter and knowing that her loss of life is going to, as Chairman Williams has said, it is going to save other lives. So we are sorry for your sacrifice, sorry for your loss, but grateful for your help in getting this bill to fruition. Chairman Hicks of Washington, you're recognized. All right, pass. All right, any other comments, questions? The question has been called. Without objection, we are voting on House Bill 1640, otherwise known as Jillian's Law. All in favor, please signify by saying aye.
Aye.
Any opposed? Let the record show it passed unanimously, and House Bill 1640 goes to calendar and rules. That brings us to item number 11, also by Leader Lamberth, House Bill 1643. Do we have a motion? Motion. We have a motion and a second. Leader Lamberth, you're recognized.
Thank you, Madam Chairman, members of the committee. So we just dealt with a very important bill, and this one is as well. They are companion bills. There's no doubt about it. I have known General Funk in Davidson County for the better part of 20 years. I knew him, private attorney, practicing primarily criminal defense, and now he's been a prosecutor for quite some time now. For years, he has asked for a grant just for Davidson County to be able to evaluate those charged with misdemeanor offenses where their lawyer feels like they are, they have severe mental health issues. Well, you really can't get to the bill that we just had unless you have intense evaluation, unless you have evaluations to figure out what type of mental health issues someone is suffering from, and that costs money. In the AA, and I would ask for y'all's support today, there's a few $1 million in there. Specifically, there is $3.3 million allocated to evaluate misdemeanor defendants, those charged with misdemeanors, to determine what services they may need, or potentially if they are incompetent, just as we were discussing. That's what this bill does. It is something the state of Tennessee used to pay for. And then in a budget crisis of some sort, way back before any of us were in the legislature, they trimmed it to where the state of Tennessee would only pay for felony defendants, those facing felonies. I've literally seen cases in court where a defense attorney would have to beg the state to amend the charges from a misdemeanor to a felony so a mental health evaluation could be paid for, only to drop it back down later in negotiations once they knew exactly what was going on with the person. Those type of legal gymnastics should never be necessary just to get somebody help. With that, Madam Chairman, I stand ready for questions.
Question has been called. I see no objection, so we're voting on House Bill 1643. All in favor, please signify by saying aye.
Aye.
Any opposed? The ayes have it. House Bill 1643 goes to calendar and rules.
Thank you, Madam Chair. Members of the committee, today you've certainly made a difference.
And we're continuing with the Leader Lamberth calendar with House Bill 1893. We have a motion and a second, and I believe we do have an amendment on this bill, Leader Lamberth, drafting code 017753.
Yes, ma'am, Madam Chairman.
We have a motion and a second on the amendment. Any objections to the amendment? Without objection, we are voting on Amendment 017753. All in favor, please signify by saying aye.
Aye.
Any opposed? The ayes have it, and the amendment is attached. So we are now, Leader Lambert, if you would explain the bill as we have amended it.
Thank you, Madam Chairman. And that last was more of technical changes that legal had found on the amendment that came through the subcommittee. So this is literally the largest business tax cut that I know of in Tennessee history. This is a $400 million a year cut going forward on the franchise and excise tax. And it is a rebate going back in this version 1 year. It would give 1 year rebate back. Ordinarily, businesses have a 3-year window to be able to amend their F&E taxes. We're allowing them 1 year on that to be able to get a rebate, genuinely just to be good partners with the business community out there and give them a significant tax cut. This is about a $700 million tax cut still. That is a significant amount of money reinvested right here into the state of Tennessee. And then again, $400 million going forward from here on out. With that, if you were to file for a rebate and you're a business in this state that has done so, you have until February of 2025 to do so. And that's a refund eligibility window for tax periods that ended on or after March 31st, 2022, and claims that are filed before February 3rd, 2025. And then if you do so, the name and the amount of the rebate that a company gets would be public record. Any suits that will be filed against the state of Tennessee for our franchise and excise tax, we've heard rumors of that out there. There is no lawsuit that exists currently, but anybody that wants to sue the state of Tennessee, and I don't recommend that because we will fight it tooth and nail, it has to be filed by February the 3rd of 2025. It requires the Attorney General's office to work with the associated departments to be able to manage in the process on the rebates here. If you get a refund and you're a business and you're refunded dollars, then any ECD credits will be taken off the top of that. That's money that's already been allocated to those businesses. And if you get a refund, then obviously you're agreeing that you don't see a problem with the structure of the law we have right now, and you would sign a waiver indicating that you will not sue the state of Tennessee for this. There's a small segment of this that allows companies to stay under the current structure for valuation purposes. That came up in the F&E tax we did last year, and we're just kind of continuing through with that. With that, Madam Chairman, I stand ready for questions.
All right, idea, Representative McKenzie.
Thank you, Madam Chair. And you know, while I guess I understand why we're here, I have a fundamental problem with businesses threatening, implying that because maybe a formula wasn't exactly right, that we're somehow a business unfriendly state financially. That's a blatant misstatement. We're very friendly to our businesses in this state. And if it wasn't this excise tax, it would be something else. So for us to, I would say, have to cut this check on fear of something coming down the pike and businesses potentially suing us because maybe an equation wasn't exactly right as far as real estate in this great state. They get a lot of benefits. Their employees, us, we get a lot of benefits from living in such a tax-adverse state, and that we're very proud of. And coming from a state that's fiscally sound, regardless of party, that they've been able to do business in this state at such a low rate, including this tax, for them to argue over this piece says that we need to go after another piece. And I know, but everybody's tax averse, but this is wrong. For us to be sitting here in this position, and I know it's not anything that the sponsors are doing, but being reactive to a real threat, to a real number that may have been calculated, you know, in a way. So I get it. I get why we're here. I'm not going to support this bill, but a message needs to go out. You're in a great state. Whatever these 80 businesses, 100 businesses, 390, however many are coming after us, for this, you ought to be ashamed. Because the way we do business, the way the state does business with its businesses is good. The bottom line that you're paying, you're going to pay more in whatever other state you go to. So for you to pick on this one and not volunteer to pay more on another one and have your employees have no income tax, low tax rates, is a shame. So again, to the sponsor, I understand. It's not big anger, this frustration is not aimed towards you, but it is toward those 80 businesses that have threatened this and the fact that we're here, unfortunately. So thank you.
Leader Lambert.
Well, that's a great speech. I agree with some parts of it, but I don't know what it has anything to do with this bill. I'm not here for that reason. This is a policy determination as to whether or not we should cut taxes. I, for one, am in favor of that. I have been since the first time we discussed this. Just because somebody's saber rattling out there about some lawsuit, I'm an attorney. I don't go through a day without some lawyer threatening somewhere to bring litigation or file some motion against me. It really doesn't bother me one way or the other. But the right thing to do is to be competitive nationwide on recruiting business to this state. And you listed many of the reasons there why we are a competitive state. One of the things that has continued to really make us uncompetitive is that there are very, very few states out there. I mean, we're down to 2 or 3 at this point that have a franchise and excise tax that is like ours. And so it is simply the right thing to do to continue to cut taxes. Again, in our version here, it does give a small rebate. And there are some waivers there in case there's a company out there that wants to try to, file a lawsuit of some sort. And again, I stated in my opening statements, as you've stated in yours, I think that would be a very unwise move. I would hope that we all move forward as a state together between businesses and the state to continue to grow jobs here, to continue to increase wages here, to do the things we've all done as a business-friendly state so that our Tennessee constituents benefit. And so the reason I'm the sponsor of this bill and the reason I agreed to bring it is I think it's good policy to continue to cut taxes and get our tax code back aligned in a way that we are more competitive than we were before this bill. And I hope we can all move forward. If you do not support it, obviously I deeply respect your vote. You represent the same number of folks I do. But I think from a policy standpoint, it's a good idea to cut taxes on businesses at a time when it is more expensive than ever to operate a business in this country. But Tennessee is a little bit better off than anywhere else. And this bill will continue to make us a business-friendly state.
Representative McKenzie.
Thank you, Madam Chair. And kind of like you, I agree with a lot of what you said, but definitely not all. We heard in our budget hearing that there were 80 companies that threatened this, and that's why this is before. So again, it's not directed at you at all, but it's directed at them, those businesses. But also, I'll say there's a cost to having a great state. There's a cost to having a state with the topography that we have and the issues that we have with weather and potential tornadoes and flood, uncontrollable things. So we're in a state that needs great infrastructure. We have a bunch of bridges. We have a bunch of water. We have a bunch of natural resources that takes a bunch of money. So again, we can cut. This isn't, they're good cuts and they're bad cuts. I would say this is a bad cut. We are one of the few states that had this model, but we're also one of a few states that doesn't have an income tax, and that affects their employees. I hope they care about that. Maybe that doesn't affect the bottom line of the corporate, but that makes this place a great place to live. So again, I think they're throwing out the baby with the bathwater on this one. These companies are. They're not realizing how great it is overall to live, work, and play in this great state. So again, thank you. Thank you, Madam Chair.
Leader Lambert.
Look, with those kind of comments, we're going to maybe recruit you to a different caucus.
Representative Freeman, you're recognized.
Thank you, Madam Chair. And I guess I have 2 separate questions here, and I'll ask the first one first. My understanding is that following on my colleague's question about we're doing this to try to avoid a lawsuit. Do we think that giving just 1 year is going to satisfy that? Or, because I mean, right now you have a 4-year look back anyway. Is that, do we think that's going to solve the problem?
Leader Lambert.
Cannot be clear enough as the sponsor of this bill. If somebody wants to sue, I think it's a bad idea on their part. Bring it. We got a whole tower full of attorneys over here that'll fight you every step of the way. And 5 or 6 years from now, some judge might give you a penny or two that your lawyer's going to take a bunch of. It's a bad idea to sue the state of Tennessee, who is reaching a handout here. And to the very businesses that may or may not be considering a lawsuit, we're cutting taxes at the tune of $400 million a year and giving a 1-year look back for a rebate on those taxes out of the kindness of our heart. I think that's a good policy win for everyone. And I would ask anybody in the business community to take a look at that and say, how can they reinvest those dollars into this state and into their employees. Give some folks raises, give some folks some bonuses, upgrade the building that they're in. Treat your employees just a little better than you were yesterday, or maybe hire a few more. Invest more deeply in the state that is investing in you, because these are Tennessee taxpayer dollars that we're sending to Tennessee businesses. That's all we ask of them. So my goal of this legislation is not to try to avoid a lawsuit. It's to have a policy win here where we're cutting taxes.
President Freeman, I believe you had a second question.
Thank you. Thank you for that answer. Yeah, I guess the other one is, and I just kind of want to flag this for the committee. I think that the loss of revenue is going to be even greater than what we're projecting here. Right now, when you are tax planning, you really don't have any incentive to decrease your net worth on your books. And my understanding is that the department has calculated the decrease in revenue based on what has been submitted in the past. And there's no interest, no need to lower your net worth on the franchise tax form. So we were taking the higher of the two. The higher was going to always be the real property. Again, I think we're going to be looking at this down the road. It's going to be a significantly larger lost revenue than what we're projecting. And I just want to flag that for the committee. Thank you.
Chairman Williams.
Thank you. Leader Lambert, want to thank you and this committee for your hard work as it relates to this subject matter. As it relates to the comments that were just made, the issue as it relates to network calculation and the property valuation on a Schedule G are completely different ways in which F&E tax is generated. The tax cut that's here is an effort people here. The reason why we've had exponential growth in the state is because this state is business friendly. All we're saying here is that we're going to continue to be friends to business by giving them the ability to take back a portion of those monies in which they already committed and entrusted to this state for a 1-year period of time. I think it's also important to say what this bill does is it provides a level of transparency. My colleague from Knox County, who I rarely disagree with, I must say that I agree with him fully as it relates to this. This is not necessarily what I would see. I would like to see just a tax cut to eliminate the property valuation and move forward from there. But that's not, unfortunately, that's not the place that we're in. But there are many businesses across the state who received ECD incentives as it relates to F&E credits, and those people are trying to utilize those credits or that promise that the state of Tennessee made to them for many years. This would allow them to continue to write that credit off their books without taking a deeper cut to their bottom lines, which makes them better corporate sponsors or citizens of the state. The state has stepped out as it relates to the other ECD provision. In many instances, spent billions. I will say again, billions of dollars in the last 5 years to give incentives to corporations to come here. And the exponential growth is because Tennessee is the most business-friendly state in the United States, which is why we have 700,000 more people than we did 12 years ago when I got elected. And so I think it's really important that we recognize the investment that the state's made in preserving the identity of businesses that are unique to our state, and also recruiting other businesses who are going to start their business here and invest billions of dollars. The transparency component, however, of this bill speaks to my colleague from Knoxville. More importantly, when we get letters of threats, or maybe Leader Lambert gets more of those than I do, but when we get threats from businesses, it puts us on our back foot in a way that we're surprised, because transparency, this veil of legal documents without knowledge of who these business interests are, is the very thing that's put us in the place that we are now. If a business had an issue with this body or a statute that we had in place, most times they come in our office and knock on our door and say, hey, help us with this problem. And what are we doing normally? Every time I've been here, we've helped a business fix the problem that was before them so that they could be more competitive in the marketplace, not just here, but all around the United States and around the world. And so I think the transparency is probably one of the most important pieces of this bill. I think being able to let someone go back 1 year instead of 3 years on these out years of F&E taxes is really important, because it minimizes the liability. I will finish with this. For more than 90 years, this is the way this business this tax has been calculated. No other place in the tax code does a business pay a quarterly tax rate 3 times a year based upon what they think the value of the F&E tax is going to be, and they true it up. They commit at the end of that year based upon their audited financial statements what they believe that full tax to be. And this bill seeks to do what we do best. That is, make Tennessee a better place to do business, more competitive, while providing a refund to those to give them an incentive to stay and invest more here in Tennessee. Leader Lambert, I appreciate the bill. I appreciate the hard work of this committee, the diligence we've had. We're not playing necessarily the hand that we'd like to be playing, but we've made the best of the hand we've been dealt, and I appreciate the committee and their diligence.
Chairman Zachary.
Thank you, Madam Chair. Question on the bill.
Just one question.
We do have an objection. We're going to vote on the previous question. All those in favor of previous question, please signify by saying aye.
Aye.
Any opposed?
No.
I believe the ayes prevailed. And we are voting on the previous question, which is House Bill 1893. All in favor, please signify by saying aye.
Aye.
Any opposed? If you'd like to be a no, then please see the clerk and let that be known. But House Bill 1893 does pass on to calendar and rules. Thank you, Chairman Leader Lambert. Next on our agenda is item 13, House Bill 2099. Without objection, that has been asked to be taken off notice. So,
sorry.
Leader Cochran.
Chair Lady, with your indulgence, if you wouldn't mind, I think the Senate, the technical term may still be mulling that one over. If I could roll that 1 week, if it's okay with you.
Over noted objection. We are rolling 1 week. All right. Thank you. Sorry, Leader Cochran, we had a miscommunication about that.
That's okay.
I do apologize. Next on our agenda is item number 14, House Bill 2240, also by Leader Cochran. Leader Cochran, we have a motion. We have second. Second, we have a motion and a second. Leader Cochran, you are recognized.
Thank you, Chair Lady. We may have an amendment to address. Is that accurate?
I have drafting code 017260. We have a motion and a second. Any questions on the amendment? Without objection, we're voting on the amendment. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. The drafting code amendment 017260 is attached to House Bill 2240. Leader Cochran, you are recognized on the bill as amended.
Thank you, Chair Lady, and I'll be brief. This is essentially it's a reporting bill, asking, or it's having counties submit a report on how hotel motel taxes are spent. I do want to make one very quick clarifying statement just for the legislative record. As stated before, this is about reporting about how those dollars are spent. There are several counties, mine included, McMinn, and I know Obion is one, that how their hotel motel tax is spent is determined by a private act. And so for those counties, for instance, they spend it on both industrial development and tourism. This bill does not change that at all, and it doesn't emphasize that should change. If it did, I wouldn't be carrying the bill because it would affect my county as well. So I just want to make that very clear. This is just about reporting how those dollars are spent. It does not have anything to do with how to determine how they are spent as far as tourism to industrial development, that type of category. But I will yield to any questions. Thank you.
And we do have a question, Representative Love.
Thank you, Madam Chair. To the sponsor, are there other counties that this, I'm trying to ask the right way, does it affect all counties, or are there certain provisions in there to only have reporting mechanisms for certain places?
Leader Cochran.
Thank you, Chair Lady. The report would apply statewide as far as you submitting a report, how those dollars are spent. So, and then it would, again, it doesn't change if you've already been approved through a private act many years ago, O'Bien and McMinn being the two prime examples that come to mind, that they were approved to spend their dollars on both industrial development and tourism. Doesn't change that. It just, McMinn County, for instance, we would send in a report and say, hey, we made 15 expenditures regarding tourism. This is what those were spent on. We made 10 expenditures on industrial development, and that's what that went toward.
Okay. All right. Thank you, sponsor.
Additional questions? Representative Lynn.
Thank you, Madam Chairman. And it does apply to municipalities as well?
Leader Cochran.
That is correct. I should have clarified that. Correct.
Further questions? Seeing none, without objection, we're voting on House Bill 2240. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. House Bill 2240 moves to calendar and rules. Item number 15 is House Bill 2729 by Chairman Faison. I have a motion and a second. Chairman Faison, you are
Madam Chair.
recognized.
Committee, so good to be with you. Before I tell you a little bit about this bill, I just want to tell you a personal story. When I was 13 years old, my sister was killed by a drunk driver. So I have certainly very strong feelings about a person who would choose to be inebriated and get behind the wheel of a car. I look down this desk from me and I see my good friend that I love dearly, Representative Gant, who almost lost his life to a drunk driver. This bill deals with that, and we have, in the last several years in Tennessee, done some great strides in the space of what happens when a person gets caught drinking and driving. When I first got here, I remember hearing complaints from people that you could get caught and 6, 7 times later and you still are out driving and still having issues. We've really cracked down on it. In Tennessee, your first offense, you can lose your driver's license for a year. On top of that offense, current law says if you have lost your driver's license from your first offense and a year later you have got your license back, if you are stopped and have not paid all of the fines and fees that came with you losing your license at first, even though you've been revoked for a year, you automatically, without question, go back to jail for 48 hours to 6 months. Notwithstanding that you have paid your debt to society as far as you haven't driven in a year, your license has been revoked. We're talking after the time has elapsed and allows you to get your driver's license back. And the only reason you don't have your driver's license back is because you have not been able to pay your fines and fees. I represent people in my district who oftentimes get stuck and don't have the ability financially to always do that. This just takes out the automatic responsibility to report to jail for 48 hours to 6 months and puts the discretion at the judge's ability to decide if they see that this person is actually on the right track, is doing best, have not paid their fines yet, but otherwise has paid everything else back to society, that the judge at his discretion can either put them in for a minimum of 48 up to 6 months or choose not to. And that's all this bill does.
Chairman Faison, I signed on to this bill because while I have no patience and no sympathy for people who get behind the wheel when they are impaired and risk their lives and others, I do think, as you said, once people have, they've suffered the consequences of that action by losing their license for a year, but oftentimes they are, having not had the license, you may not have been able to work, and your financial position is such that you might not be able to pay what are substantive substantive fines and fees. So this, again, it's not saying that you don't have to do that in order to get your license, but it is just allowing the judge that discretion to see if somebody's actually, trying, and the judge will have the ability to do that. So I commend you for the legislation. I heard Question called, and I hear no objection to that. So we are voting on House Bill 2729. All in favor, please signify by saying aye. Any opposed? The ayes have it. If you'd like to be shown as a no, then please see the clerk. Number 16 on our agenda, House Bill 2793, also by Chairman Faison.
Thank you, Madam Chair Lady.
You are recognized.
Committee, is certainly still good to be with you. When I was first elected, there were 16 counties that were considered on the distressed counties list. Through our actions, through the actions of Governor Haslam, through the actions of Governor Lee and the House and the Senate, we've created policies that have got us all the way down to 8 counties that are distressed. Currently, if you apply for a TIF, you have basically till the end of this year to be able to do that. If you're a distressed county, this is just extending the deadline for distressed counties to be able to apply for a TIF to use the money locally that they get in tax revenue to June 30th, 2031.
You've heard the sponsor's explanation. Are there questions? Question has been called. Without objection, we are voting on House Bill 2793. All those in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. House Bill 2793 goes to calendar and rules. Next, we have House Bill 2426. Chairman Hicks, we're being very formal, and Chairman Hicks has chosen to present his bill from the podium. You have a motion and a second, and you are recognized. We
Thank
do
you.
have an amendment, I believe.
We do. Thank you, Madam Chair. We do have amendment 017742.
We have a motion and a second on the amendment. Without objection, we are voting on the amendment 017742. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. Amendment 017742 is attached to House Bill 2426. Chairman Hicks, if you would explain your bill as amended.
Thank you, Madam Chair. House Bill 2426 makes changes to the County Powers Relief Act to further assist counties financially for schools. The amendment states that the resolution or ordinance to impose the tax must be adopted by 2/3 vote of the entire county legislative body. The ordinance must have 2 consecutive meetings, and the ordinance must be identical at both meetings. In 67-4-2907, the amendment changes the qualifications for the tax to a 20% increase between the 2010 and 2020 census, or a 9% increase over the last 4-year period according to a special census. The county must conduct the special census at their own expense. After initial qualification, the county may use federal census estimates to maintain the qualification based on growth. The comptroller must verify all the numbers and review the county's qualifications. As amended, this adds commercial property to the County Powers Relief Act. This bill updates the definition section and changes the definition of development to include residential and commercial properties. Public buildings, nonprofit buildings, mega sites, and other buildings remain exempt. Square footage is based on finished, heated, and cooled floor area. In 67-4-2908, the proposal is to increase the tax from $1 to $1.50 per square foot on new commercial and residential property. Counties can increase the rate of the tax after 4 years by a percentage of 10%, and they must adopt the increase 2/3 vote of the ordinance following the same procedures as outlined above. This tax is due upon completion and must be paid before getting the certificate of occupancy. So with that, I'll be happy to answer any questions, evidently.
I believe, sponsored you, that you have fully explained your bill to the satisfaction of the members of this committee. And so without objection, we are voting on House Bill 2426. All in favor, please signify by saying aye. Aye. Any opposed? No. The ayes have it. If you'd like to be recorded as a no, then please see the clerk.
Thank you, Madam Chair, and thank you, committee.
I'm sorry, I just didn't see it. Next on our calendar is item number 18, House Bill 1191. Chairman Williams, you have a motion and a second, and I do believe that we have an amendment.
Yes, Chair Lady, drafting code 015984.
That's what we're showing. Do I have a motion on the amendment? We have a motion.
Second.
We have a motion and a second. Chairman Williams, you are recognized. Please explain your bill as amended.
Thank you, Chair Lady and members. This is a bill that we had much discussion on several weeks ago. Being a W on the Chair Lady's calendar makes it difficult to be heard again. And so this bill simply makes changes and updates the definition of vacant properties as it relates to purchases and leases of those vacant properties. As the members know, we had a great discussion about this last time, and there was brought to my attention that one of the descriptions of the bill was mute on it. This amendment that we put on the bill today would simply clarify that, in that the properties that are sold by the LEA or municipality will be allowed to use the same formulary if the charter school chooses to sell that property at a later date. With that, Chair Lady, I'm happy to answer any questions the members might have.
Are there questions of the sponsor? Representative Shaw.
Mr. Chairman, this is the one that gives the chartered schools the advantage of taking property from public school systems if they choose to. Is that what I'm kind of looking at here?
Chairman Williams.
This property doesn't take any property. This bill simply allows for a first right of refusal and a means by which a purchase can be acquired, and enables the comptroller's office to be the independent third party as it relates to any list in a county or municipality where a charter school exists as it relates to those charter schools. As members recall from our previous discussion, charter school students are public school students. They receive public dollars. However, those dollars are not able to be utilized to fund the construction maintenance of those schools. They use those dollars in order to do that themselves, as they do it the old-fashioned way with bootstraps. And so this bill simply gives them an opportunity to purchase or lease those buildings. And if they no longer need utilization of those buildings, they can be sold back to the municipality in which they bought them from.
Representative Shaw.
I'm trying to get my arms around it. Why would the comptroller need to be involved in personal properties such as that, when the local governments and all the local folks should be, in my humble opinion, have the right refusal to sell or to do whatever they wanted with that property? Why would the comptroller need to be involved in that process?
Chairman Williams.
Thank you, Chair Lady. The reason for the comptroller's office would be much like they are an independent third body as it relates to the cataloging and requiring of this. It's not unusual for the charter or for the comptroller's office to oversee this type of thing, even current practice as it relates to vacant buildings.
Representative Shaw.
So then if my local public school system had a building that they were no longer using, and there was a charter that wanted that building, they would have the first right to it over and above maybe if some businessman in the community wanted to buy it and develop it and do something else with it, or whatever the case may be. From what I'm understanding is the chartered school would have the first right to that property to buy it if they wanted to. Is that correct?
Chairman Williams.
Thank you, Chair Lady. The term first right of refusal is giving the charter school the right to say no. If under the premise that you currently described, if someone came and they offered the local LEA what they believe to be the fair market value of that property, and the LEA chose to sell to that individual, they would just allow them the opportunity to purchase that property at the same value, not less. If the property was not desirous of the gentleman from your district, and it was just vacant property, then the methodology would be a fair market value appraisal by both the LEA and the charter school, and the average of those would be the price that is set to buy it.
Thank you, Madam Chair. Thank
Leader Camper.
Thank you, Madam Chair. Chairman Williams, the amendment that you put on, was that the amendment? Did that amendment come out of the conversation the last time we heard this with respect to the LEA? Should the charter school purchase it, put it back on the market, that the LEA get an opportunity to repurchase it back?
Chairman Williams.
Yes, Leader Camper. There was a guy that was here earlier in a red and black plaid jacket that asked that question last session, who is now away without leave. But this amendment would correct the discussion that he and I had. Thank you.
I just want to make sure that's what we were doing.
Chairman Zachary.
Thank you, Madam Chair. Question on the bill.
Question has been called. Without objection, we are voting on House Bill 1191. All those in favor, please signify by saying aye. Aye. Any opposed? No. If you'd like to be recorded as a no, then please see the clerk, but House Bill 1191 passes and goes to calendar and rules. That brings us back to the Hill and Chairman Kiesling, who has been patiently waiting to present House Bill 2152. Do you have a motion?
Yeah, I know.
We have a motion and a second. Chairman Kiesling, you're recognized.
Thank you, Madam Chair, Chair Lady. This bill was brought to both Senator Yeager and I from the Scott County Commission. It requires a judge of the General Sessions Court there in Scott County to devote full time to the duties of said office, and prohibits the judge from the practice of law or any other employment which conflicts with the performance duties as a judge. In addition, we also have a resolution, Madam Chair, that was voted unanimously in favor of this. So with that, I will entertain any questions.
Questions? Question has been called. I see no objection. We are voting on House Bill 2152. All in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 2152 goes to calendar and rules.
Thank you, Chair Lady.
That does complete our calendar for today. We have any further business for the committee? Seeing none, we stand adjourned.